All right, so let's talk about competence. It requires legal skill. It requires knowledge. It requires thoroughness and preparation, and preparation, reasonably necessary for the representation. Attorney-client confidentiality includes everything related to the representation of the client. Everything, including anything the lawyer obtains that's public record. If it's a conflict that can't be waived, then the lawyer has to withdraw. If it can be waived, then the clients need to be both fully, there has to be full disclosure with an informed consent. We want you to continue to assist us.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, I want to go ahead and kick things off by introducing our speaker, Joseph Korsmeyer. Joseph A. Korsmeyer is an AV-rated attorney practicing in Palm Harbor, Florida. He concentrates his practice primarily on the areas of defense of attorney disciplinary matters before the Florida Bar, attorney admission matters before the Florida Board of Bar Examiners, and professional license and disciplinary matters before the Board of the State of Florida. He provides expert analysis and opinion on conflict of interest and other attorney disqualification and legal malpractice issues, and he has testified as an expert in both the federal and Florida courts. The webinar presentation that you're about to watch will be about 1 hour, and Joseph will be taking questions once the presentation is complete, time permitting. So if you have a question that comes up that you'd like us to address at the end in the Q&A portion, please be sure to submit that by clicking the Q&A button in the control panel at the bottom of your screen and sending it in there. Now, without further ado, here is Joseph Korsmeyer to discuss Ethics 101, Essential Guidelines for a Lawyer's Practice.
Thank you, Nina. Hello, everyone. My name is Joe Korsmeyer, as Nina said in her excellent introduction. I am a former Florida Bar attorney. I'm a Florida admitted lawyer. I'm admitted also in the Middle District of Florida federal courts and the 11th Circuit and the U.S. Supreme Court. I spent 8 years as a Florida Bar prosecutor, bar counsel. Since that time in 1998, I've been defending lawyers in bar complaints and also providing ethics advice to lawyers throughout the state and also throughout the country on multi-jurisdictional practice issues. I also provide expert opinions related to the rules regulating the Florida Bar. I've been retained numerous times and actually am currently retained on various matters. I also provide licensed defense, individuals who are licensed in the state of Florida. I provide them with advice and counsel and defend them. And finally, actually, I probably should include this first, I represent lawyers, as Nina said, who are applying for a license to practice in the state of Florida. So without further ado, let's talk about lawyer ethics, maintaining an ethical law practice, and understanding ethical issues and obligations. There's my information. You'll have that. Nina will say, Justia will send you the materials, these materials, but I am practicing in West Central Florida in the Tampa Bay area. I've been here for many, many years. So let's get going on this. I think it's very important for lawyers to understand. And this is essentially a basic course. It may go a little bit in an intermediate, but basic course with regard to lawyers' duties and obligations under the bar rules. And I have designed it to be multi-jurisdictional. So if you are a member of another bar, not in Florida, I will be talking about the model rules. But the main point that I want to make is this is these are concepts that apply throughout the country. But I will say this: make sure that you check your own jurisdiction's rules and ethics opinions. If you have any questions, this is not, I'm not giving ethics, or I should say legal advice or ethics advice at all. Finally, if you see my email address there, I publish what are called ethics alerts, where I give lawyers throughout the country information on bar rule topics, interesting ethics issues, and things of that nature. If you want to join, you can send me an email and ask to be on the email list, or you can go to LinkedIn. I have an ethics alert group in LinkedIn, also on Facebook, and also on WordPress as well. I started my blog on WordPress. Okay, so without further ado, So let's talk about the keys to ethics in law office management. I'm going to talk about duties of subordinate lawyers, the lawyers who are being supervised, the supervision of lawyers, requirements for supervising lawyers and non-lawyers, client intake, which I believe is a very important consideration in lawyers' practice, depending on the type of practice. Actually, I will say there's always going to be a client intake process. Competence in practicing law, conflicts of interest, client confidentiality, managing client files and client matters, file closing and records management, and also ethics regarding billable time and ethical fees and fee agreements. I'm going to be covering a lot of material here in 60 minutes, but there may be some additional material that you have in this PowerPoint that may be helpful to you if I don't get to it today. So let's talk about supervising lawyers and non-lawyers. And as Nina told you, by the way, I'll be taking questions at the end of this webinar. I'll be going for 60 minutes. So if you have any questions, keep them, or you may be able to send them in the chat, but keep them and I'll try to answer them at the end. So lawyers are responsible for the actions of both non-lawyers and subordinate lawyers under certain circumstances. That's correct or true in every jurisdiction. And it's based on the agency and principle, or what we lawyers call respondeat superior in Latin. So, it's a doctrine where a supervising lawyer may be responsible or liable for non-lawyer and subordinate lawyer conduct. So it's a modified it's a modification of agency and principle. So I'm going to talk a little bit more about that. So under the model rules, and always check your jurisdiction on these rules, a lawyer who has direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct under that jurisdiction's rules. A lawyer shall be responsible for another lawyer's violation of the rules if, number one, or there should be a one there, the lawyer orders or with knowledge of the specific conduct ratifies the conduct involved. So scenarios, the lawyer says to a non-lawyer, go solicit for me, give my card out at the busiest intersection when there's an accident and tell people to hire our firm. That's obviously ordering a violation of the bar rules. Other examples would be, and I'll talk a little bit about this on social media, is telling a paralegal to go ahead and try to friend the opposing party so it can get some dirt on them if they have any dirt in their non-public private part of their Facebook page. That would be ordering a violation. And then the second part is specific conduct. The lawyer ratifies the conduct involved. So out to all the intersections around town, we're a personal injury firm, so we need new clients. And I've been handing out your card and telling people what a great lawyer you are, what great law firm we are. And the lawyer says, great, keep it up. That would be ratifying it. Okay. That's pretty simple, but that's really how it works. But number two is if the lawyer is a partner, and this is important to know, or has comparable managerial authority in the law firm in which the other lawyer practices, or has direct supervisory authority over the other lawyer and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Okay, so here's the way it would work. And I've handled these on the prosecution side. Law firm has a lawyer who's stealing money from the trust account. And the law firm knows all about it, including the partners, and they don't tell the bar. They don't take measures to try to correct it. Or maybe they do, but they don't tell anybody. So that could be, and it's not always, but it could be that the partners would be responsible, if they know about it, for that conduct, and of course, failing to take reasonable remedial action or to avoid or mitigate the consequences, which would be reasonable remedial action is the same thing as mitigating, or trying to mitigate it. So in that case, the lawyer who's a partner would be responsible. And if they're not a partner, if it's if it's not a partnership, if it's a shareholder, it's The key is managerial authority in the law firm itself. The second part is if the lawyer has direct supervisory authority over the lawyer. In other words, a senior associate could be responsible for the conduct of a non-lawyer or of a subordinate lawyer if that lawyer knows about it. And this is really important under B. A lawyer shall be responsible for another lawyer's violation of the rules if, and I already went over this, so I just remembered I went over this. I got a little bit distracted here, so let me go to the next one. A lawyer is bound by the rules, notwithstanding that the lawyer acted at the direction of another lawyer, or another person, I should say. So it's important for subordinate lawyers to know that if the partner or a supervising lawyer tells them to violate the bar rules, they can say no, and they should say no, and they pretty much have to say no because they will be responsible for their conduct, even if the lawyer told them to do it or another person told them to do it. So lawyers need to be aware of that. That's subsection A. B is, there says a subordinate lawyer does not violate the rules if that lawyer acts in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. I actually had this issue come up in my practice. Actually, it was again, as a prosecutor, and the question was, did that lawyer, was it a reasonable resolution of an arguable question of professional duty? In that case, it turned out it was. It was a gray area as opposed to a black and white. And so that lawyer was not prosecuted, but it was investigated, because I think it was reported by a client actually, or maybe by sometimes the bar. And this happened to me when I was a bar prosecutor. I'd receive information from an employee who had been fired, who was disgruntled or quit because they didn't like what the law firm was doing, and maybe they were violating the rules. That happened to me probably 2 or 3 times where I received a complaint like that. So that has to be investigated, of course. All right. So, and this is basically where the rubber hits the road. With respect to a non-lawyer employee retained, for non-lawyers, an associate with the lawyer, a partner, again, a partner or lawyer who individually or with other lawyers possesses comparable managerial authority shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of lawyer. You could tell a lawyer wrote this rule. There's a lot of words, but the key to this is to understand that if the lawyer, for instance, I'm a sole practitioner, and I actually I have a paralegal who's my son. He's actually a legal assistant, and I gave him the rules. You have to keep confidences, and that's what I advise you. I advise a lot of lawyers and law firms, particularly in the state of Florida. And if a law firm's small, maybe taking that reasonable effort or making those reasonable efforts would be to provide copies of the rules and say, you've got to follow these rules. You've got to maintain confidence that you can't tell a significant other about things that are going on in the firm that are confidential. Have to maintain that, and communication, you reasonably communicate. So and some big firms have a handbook that they hand out to every employee. And I've helped law firms create those handbooks as well. So it's important to know that there has to be reasonable efforts to ensure that a person's conduct is compatible with the bar rules, basically. And then in subsection B, a lawyer having direct supervisory authority of the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible. So it's the supervising lawyer, who doesn't have to be a partner, would be required to do that as well. So it's important to understand that, and sometimes those issues will come up. And again, if the non-lawyer violates the rules, or if the lawyer can't order the non-lawyer to violate the rules or ratify the conduct, the same as 5.1. And again, comparable authority or partnership may create some liability of those other individuals who have managerial authority, or if a lawyer has direct supervisory authority over the person. So again, that's an important rule, in my opinion, because and I've had issues come up where I've defended, and also where I was investigating cases involving that. So here's a few tips for compliance with the rules. Lawyers should take steps to ensure that non-lawyer staff maintain client confidentiality, as I just said, as required by the attorney. That should be lowercase, pursuant to the rules. Do not permit non-lawyer staff to negotiate settlements. And I have in other webinars, I have this as a topic that I expand on more than the time that we have here. But there are ethics opinions, including in Florida, that state that non-lawyers cannot negotiate settlements. And so what does that mean? Non-lawyer, a trusted 30-year, I had a 30-year paralegal who worked for me a number of years ago. I did workers' comp, and that paralegal knew more than I did. So I would use her as a resource, but she didn't negotiate settlements for me. And some lawyers, for whatever reason, may allow that to happen. It can't happen. Now, those of you that may handle personal injury or or workers' compensation or other matters where there are adjusters involved, insurance matters, may know that adjusters sometimes think that they're lawyers and they like to negotiate settlements because they don't want to bring lawyers in. That's different. That's, it's not like we want to run around and report these adjusters for practicing law. They're just trying to do their job. So I'm not trying to minimize it, but there have been occasions, and I've actually had occasion when I was doing that type of work. I don't do it anymore, to talk to the adjuster and say, listen, please run this by your lawyer. I'd like to actually talk to the lawyer who'd be assigned to this. And occasionally it worked because it was a little more complicated than what I believed I should be doing with an adjuster. So keep that in mind. Don't permit non-lawyer staff to discuss and or interpret the terms of the fee agreement with the client or the prospective client. And in other webinars, I'd expand on this a little bit. There are ethics opinions, and I may actually have them in these materials, where the fee agreement is a legal document. It can't be interpreted by anyone other than a lawyer. And so if a prospective client comes into the door and is met, and meets, I should say, with a non-lawyer who then presents them with a fee agreement, that non-lawyer is the only one that they're talking to. So they may very well have legal questions. So the lawyer has to be involved. The lawyer should be involved. My recommendation is the lawyer be involved from the beginning and be a part and conduct the potential client, interview. But if the lawyer's not going to do that, at a minimum, the non-lawyer should be advised not to discuss or interpret the terms of the fee agreement or to give any legal advice. And that should be said from the very beginning. Paralegals, non-lawyers, if they're talking to a client or anybody else for that matter, should say, I'm not a lawyer. I don't play one on TV. I'm not going to give any legal advice. Also ensure that non-lawyer staff explain to the client that he or she cannot provide, as I just said, a legal opinion or provide legal advice. Both attorneys and non-lawyer staff should explain to a prospective witness that he or she, that individual is not disinterested in the matter. And I talk about that in other webinars as well, where then a non-lawyer, maybe a paralegal, is calling a witness, that paralegal should say who they are, who they're with, why they're calling, and ask them if the person's represented by counsel or an attorney. If they're not, they can talk to that individual. And my strong recommendation is that little colloquy be done before the paralegal talks to the witness. Here are some Florida bar ethics opinions as examples. So under the two ethics opinions at the top, non-lawyer employees can be listed on firm letterhead and business cards if non-lawyer status is disclosed. And I'll expand on that. That's an old ethics opinion, but nowadays websites should have disclaimers. They should have, if there's going to be a drop-down menu, it would be a list of lawyers and a list of non-lawyers, and they should be clearly identified. This is an oldie. Non-lawyer employees are prohibited from signing a lawyer's name to pleadings or other court documents. Nowadays, we have e-filing, and most, if not all of you, e-file. And it started with the federal courts. Now we've got states doing it. Florida does it. So a non-lawyer in Florida is permitted to electronically sign a lawyer's name. And that's actually in an ethics opinion. That's a newer ethics opinion than this. In the old days, it was a wet signature, as we call it now. And the paralegal or non-lawyer could not sign the lawyer's name to the pleadings, even if they put their little initials on the, there's actually an ethics opinion that says, hey, we put our initials on the side of it. But with the new e-filing situation, new in the sense of, it's post 1987, in Florida, at least, non-lawyers can electronically sign the name. But it's very important to understand that, and I may have there's a case out of Chicago. There's more cases than just this one, but there's a case out of Chicago where a lawyer had a paralegal electronically file complaints against individuals who were not paying their student loans, and they've been contracted with the Department of Justice, and the pleadings were filed, which were fine. The complaint was filed or fine, but the pleadings had private information. It had email addresses, home addresses, social security numbers, and the lawyer got into trouble, admitted it, and admittedly messed it up and received a reprimand. So be careful about that. When we're electronically filing, I would say that lawyers must know what exactly is being filed, including any and all exhibits. All right. There's the ethics opinion from 1974 in Florida. Non-lawyers cannot engage in settlement negotiations. The next one down, lawyers are prohibited from including non-lawyer employees in overhead. So there can't be, we're going to charge you X amount of dollars for our secretarial services. That's overhead. And then bill for it too. Can't do both. And actually the overhead needs to include secretarial. It's not billable. A paralegal time is billable, of course, as we know. And the last one, non-lawyer employee bonuses cannot be based solely on the number of hours worked. It's prohibited, but may be used as a factor to decide if a bonus will be paid and the amount. These are for example only. Check your jurisdiction if you're interested in these issues and what your jurisdiction's opinions say, or what the bar says, your bar says. All right, what about client intake? So it's important, depending on your area of practice, it'll vary as to the client intake form. But I think pretty much every practice is going to use a client intake form in some way or shape or form. But these are some tips. Basically, make sure you know who all the parties are and how the client was referred to the office, because it may be that they're on their fifth lawyer, and their previous lawyers had fired them because they were so problematic, or PITAs, as I call them, pain in the you know what. Always run a conflicts check prior to the potential client's appointment or before you begin the consultation. It's important to know if there's any conflicts before you even get into the consultation. If there's going to be a consultation fee, make sure the client is aware of it before the consultation begins, or they won't be happy. They probably won't pay it. Non-lawyer employees are permitted to conduct initial client interviews, but the practice is discouraged. And this is actually a Florida opinion that says this, but I think it's good. It's a good process to use. And that is, if there's going to be an initial client interview by a non-lawyer, they should be well aware of the fact that they cannot give legal advice. They need to identify themselves as non-lawyers from the very beginning and be limited to gathering factual information. The paralegal that I had, basically she was a 30-year paralegal in workers' comp. There was a questionnaire that was completed, and those questions were asked by my paralegal, or was completed by the potential client, and then the paralegal would go over it with that person. And it was only related to facts. Screen for potential conflict at the beginning of the representation. This is a little bit more of an expansion of what I just said. Was the client previously represented? If so, why did the representation end? Unreasonable expectations and or failure to listen. I can't tell you how many times, and I've been living this typically, or I've seen this typically vicariously, is because I deal with professionals mostly. Watch out for unreasonable expectations. Personal injury case. I want $1 million, and then they won't come off of that, and they won't listen to the lawyer, and the lawyer needs to make a decision. First of all, do I want to take this bender case and have to put up with whatever it is with a problem client? So that's something the lawyer has to decide. Lawyers don't have to take cases. Back in the early days of lawyering in the United States, there were some rules, some jurisdictions, some courts. It was run by the courts would require a lawyer to take a case if a client came in their door. Believe it or not, that's actually an historical fact. All right, never guarantee results. Results I actually have in my fee agreement that I don't specifically in a paragraph. I don't guarantee results. Actually, in a provision, part of the if there's a contract with a potential client, I'm sorry, contact. So don't guarantee results is the bottom line on that. If there's contact, if the lawyer has contact with a potential client and there's no representation results, the lawyer would recommend the lawyer send a lawyer who's not taking the case to send essentially a non-engagement letter. And it could be a non-engagement communication. If the communications have been through email and it's been, the potential clients responded. So after a consultation, there could be I think a letter is probably better. I'm unable to take your case. It doesn't mean you don't have a case. You don't want to say because you have a terrible case because that creates problems. So it doesn't mean they don't have a case. Encourage the individual, not the client, because they're not becoming the client. Encourage the individual to consult with other lawyers. Advise generally of any potential statutes of limitations and or any other deadlines that might affect the client's rights. Depending on your practice, depending on the lawyer's practice, conduct conflict checks as existing matters develop, and if new parties are added, or if it's a new matter for an existing client, or a matter undertaken for an affiliate of an existing client. So I've helped lawyers who have or in law firms where there are multiple offices, sometimes throughout the United States, sometimes in the state of Florida, sometimes both. It's important for there to be and it's easier to do nowadays than it was before the age of electronic, our age, digital incorporation of information or obtaining information and collecting it. But the conflicts check should be run through the entire law firm, not just in one office, of course. Because I had one occasion where I represented a lawyer who took on a client. There's a homeowners association, and the law firm had multiple offices, and there's a conflict with that existed in one of the other offices, other than this clears in the Miami or Fort Lauderdale office, and that conflict raised its ugly head, and a bar complaint was filed against the lawyer, and I represented that lawyer. The result was not horrible for the lawyer, but the lawyer had to pay me and go through the process. So conflicts checks are really important because in the real world, sometimes they can create huge problems. And one of the problems that I've seen too is if there's a conflict that's not identified at the proper time and the lawyer is required to withdraw or is disqualified, the client can move for disgorgement of a fee, both with maybe the Florida bar or with the court. So that's even worse because the lawyer may be required to disgorge a fee. So it's better to do the screening early and catch a conflict than to have the consequences if and when it occurs. So I have this is actually Model Rule 1.9. In Florida, it's 4-1.9. It prohibits representing a new client against a former client in the same or substantially related matter in which the new client's interests are materially adverse to the former client's interests. So what does that mean? If the lawyer is approached by an individual who the lawyer where the lawyer represented a client and no longer represents that client in the same or substantially related matter in which that new client's interests are materially adverse, that's a conflict of interest. And it can be waived theoretically, but I've never seen an occasion where a former client agrees to waive a conflict against their lawyer to allow that lawyer to represent their basically an opposing party, essentially. So I've never seen it waived, but it's important for lawyers to know. And again, check for this type of conflict at the beginning and even before the representation begins so that it doesn't raise that problem isn't raised later on. All right, so let's talk about competence. So competence is multi-part. is a multi-part equation in the rule, in the model rule, in most, if not all, jurisdictions. It requires legal skill. It requires knowledge. It requires thoroughness and preparation, and preparation, reasonably necessary for the representation. So in the real world, the way that's looked at is did this lawyer completely fail in their legal knowledge, skill, thoroughness, or preparation? When I was a bar prosecutor, I prosecuted a lawyer who was filing appeals with the Second District Court of Appeal and totally botching them up, not paying the filing fee, filing an appeal when it wasn't appropriate, and it was sufficient to give rise to a prosecution for lack of, for being not lack of competence. And I was handling the case. I brought in a parade of District Court of Appeal judges to testify against this lawyer for different things that he had done. And the lawyer actually was suspended for what we call in Florida is called a rehabilitative suspension. It was 91 days or more. I can't remember the number. But also the court said that lawyer had to undergo a mental health evaluation if he wanted to get back in. The lawyer never tried to get back in. This was back in the 90s. But it was a pretty terrible situation for the clients that the lawyer took on, because some of them lost the court. The District Court of the Appeals Court tried to keep the clients from having their interests prejudiced, and they did the best they could. But it was not a good situation. And also the comment in the model rule and in Florida includes a requirement that the lawyer keep abreast, in the words of the rule, in the law and its practice, including the benefits and risks associated with relevant technology. It's a big deal for lawyers to. Now, here's the question. Does a lawyer know enough to be able to tell the IT person or a media person who's helping them out how to do their job? No. What the lawyer needs to do, though, is to make sure that these individuals know what the issues that would be created if that third party vendor doesn't follow the rules. So, for instance, creating a website, there are requirements for websites, advertising, things of that nature. So, of course, check your jurisdiction's rules on that. In Florida, it's a very serious requirement, and lawyers have been investigated and disciplined for failing to take appropriate action to make sure that their various media presence complies with the bar rules. All right. What about conflicts of interest? So the model rule 1.7, the general rule, check your jurisdiction as to what the number is in your jurisdiction, but I believe every jurisdiction has this rule. It addresses the requirements for the representation of multiple clients in a single matter. I just got a question. I will try to adjust it. I will address that. We'll try to address that at the end of my presentation. All right. To be valid, waivers of conflict of interest must be after full disclosure and informed consent in writing. What does that mean? Informed consent is the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and a reasonably available alternative to the proposed course of conduct. Risks of and benefits of it should be both, as well as the available alternatives. I'm not going to go into the weeds on that or go into more detail on that, but lawyers need to be aware of this. A multiple client situation, if the lawyer is going to represent multiple clients, and there are examples I can give you, multiple beneficiaries in a probate case, multiple passengers and the driver in a personal injury case. Those are potential minefields as to representing multiple clients and having issues with regard to a conflict of interest. And also husband and wife. Should lawyers represent a husband and a wife in a divorce case? Absolutely not, in my opinion. I mean, it's in Florida, it's virtually a per se conflict of interest that cannot be waived. But there are all kinds of problems if the lawyer takes on that representation. I've helped lawyers through that issue or through situation, even when the lawyer has said, I'm not representing either of you. I'm just going to, prepare documents as you've instructed me. That still has resulted in a bar complaint against the client that I handled because the one spouse became soon to be ex-spouse, became disgruntled with that lawyer, filed a bar complaint. The lawyer was not disciplined, but had to explain the situation, even though, and that the lawyer put in writing that she was not representing either. My recommendation is to never represent a husband and wife. Also, my recommendation would be never to represent co-defendants in a criminal case because of the potential adversity and also ineffective assistance of counsel claims against that lawyer. After the criminal case is either disposed of, either tried and the person's convicted or otherwise. But as far as multiple clients, if their interests become adverse, the lawyer is typically going to be required to stop representing all the clients because the lawyer has confidential information from all of the presumed to have confidential information from all the clients. And then actually the lawyer may become a witness because if one client says, hey, the lawyer told us to do this, or I told the lawyer this, and the other client after the lawyer's gone says, no, nothing of the sort was said, guess who becomes a witness? Yes, the lawyer. And it's not a pleasant situation. I've helped lawyers throughout, in my career with those types of issues. So keep that in mind as well. So be careful, check your jurisdiction's rules, and think about it, about the potential issues before you agree to represent multiple clients. So always, let me put it this way. Business transactions with clients can be a huge problem. So my recommendation is to avoid business transactions, including loans or acquiring an interest adverse to the client. The model rule is 1.8. If a lawyer, here's an example. The lawyer says, hey, I'll invest in your company, client, or hey, client, can you invest in my company? That's a business transaction. Actually, I had one client who purchased property from a client. That it doesn't matter if it's related to the representation of that lawyer. It's only is it a business transaction. So it's a conflict of interest, and it's prohibited unless strict requirements are met. And I have the requirements here. Check your jurisdiction's rule. The transaction and the terms must be fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. The second is the client must be advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel on the transaction. And the last one is there has to be informed consent, as I mentioned in an earlier slide. It must be in writing, in a separate writing signed by the client, to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. So if the lawyer's not representing the client in the transaction, that needs to be put in that writing. It's not prohibited to deal with the client without that client being represented. It's actually better if the client's represented by an attorney. I can tell you that, because then that attorney would obviate the need to have this. It would be less of a problem. So loans. I will mention that a lien obtained by the lawyer to be paid a fee against, for instance, a piece of property is not prohibited. And I recommend if a lawyer is going to do that they comply with this full rule, even though it's not necessarily true that the lawyer has to comply with this rule, but it's always better to cover this. And if any issues come up later on where the client's arguing that they didn't know what was going on, sometimes clients have a tendency to say later on, even if they did understand, arguably, that, hey, I didn't understand this, the big bad lawyer was taking advantage of me. So just be careful out there, as I say in my ethics alerts too. All right. What about confidentiality? So it's important to understand what confidentiality is. Attorney-client confidentiality includes everything related to the representation of the client. Everything, including anything the lawyer obtains that's public record from the public. An article in a newspaper that's obtained during the representation is confidential in the context of attorney-client confidentiality. The lawyer cannot reveal any confidential information unless there's an exception. And I will point out that that is far different than privilege. Privilege is a litigation concept, and it's much more limited in its scope, and it's dealt with by the courts, and it typically includes communications between the lawyer and the client. Mostly that's really the main issue. The name of the main part of the privilege, as you all well know, attorney-client privilege communications, and some other. It depends on your jurisdiction as to how extensive privilege is. The lawyer can give an informed consent to reveal confidential information. That has to be same as any other informed consent. It has to be in writing, where the client's given risks and benefits, alternatives, things of that nature, and the client signs that informed consent, waiver of confidentiality. The rule under subsection B requires, and this is check your jurisdiction on this because not all the rules are the same, but it would typically requires disclosure of confidential information to prevent a client from committing a crime or to prevent death or substantial bodily harm to another. There's a financial exception in the model rule, but check your jurisdictions on that issue. This is a mandatory disclosure, and it's different than the crime fraud exception to privilege, in that it requires the threat of substantial injury or death, or the serious financial injury under the model rule, and maybe included in your rule, to require that information be revealed. Permissive exceptions are in subsection C. Includes responding to a bar complaint, a legal malpractice claim, or criminal allegation against the lawyer. Subsection D requires the lawyer to only reveal information that's necessary for the lawyer to defend him or herself. So keep that in mind, and obviously check your jurisdiction's rules on that issue. When disclosure is mandated or permitted, the lawyer shall disclose no more information that is required to meet the requirements or accomplish the purposes of this rule. As I said, as I didn't say, but I will say now, if you ever have the unfortunate circumstance of receiving a bar complaint and you're doing your own response, this rule applies. And if the lawyer goes overboard, and I've seen examples of where lawyers have thrown the mud against the client, which on things that had nothing to do with the bar complaint, and they've been looked at for that being a problem. And this next section, an internet complaint against the lawyers is not an exception to the bar rules, I should say, to the confidentiality and bar required by the bar rules. And a lawyer is prohibited from providing confidential information in response to such a complaint. And I believe I might have, let me see if I check a jurisdiction. I believe I have, and as we move forward, I think at the end of this confidentiality section, I have a couple of examples. So a fundamental principle in the lawyer-client relationship is that in the absence of the client's informed consent or an exception, the lawyer must not reveal information related to the representation, and its confidentiality remains, confidential information is confidential even after the client dies. Now, there may be a jurisdiction that has an exception, but most, if not all, jurisdiction require the lawyer to maintain confidentiality after the client dies. And the lawyer should not reveal confidential information if it will injure the client's interests unless there's an exception or legal requirement. And competences should only be disclosed based on an exception or to advance the client's interests. And I will say, if it's done to advance the client's interests, then the client should be told, and there should be an informed consent waiver of confidentiality. An example of where the client might not be available would be if the client's deceased. And in cases where a lawyer's prepared a will, estate documents for a client, and they pass, and then a lawyer is challenging that will, or I should say a beneficiary or potential beneficiary is challenging that will, challenging the will or the trust, whatever it is, then the lawyer needs to make a decision as to whether to provide that information to this lawyer who's representing, for instance, one of the beneficiaries or even all of the beneficiaries. That's a sticky wicket, for want of a better term. Jurisdictions vary on how to approach that, but the main thing to consider is if there's for instance, a subpoena for those records, or if there's a request for the records, the lawyer should just give all the records and give all the information to the lawyer representing the beneficiaries. There should be a court order because that protects the lawyer with regard to revealing confidential information under the rules. And of course, a violation of the bar rule may result in disciplinary sanctions. That does not occur typically in the privilege context because courts may sanction the lawyer, but it's typically not going to result. A violation of privilege is not going to result in a disciplinary sanction unless the bar hears about it. But rarely, if it's not, unless it rises to the level of some serious misconduct, it's not going to be reported to the bar. All right, so here's the case where the associate who was in Chicago was responsible for debt collection cases. His non-lawyer assistants prepared complaints and exhibits, filed them in the Illinois Northern U.S. District Court through the CM/ECF filing system, which has been around for 20, 25 years, maybe 30. And there's a box that's checked, and now all other e-filing typically has this box. I know Florida does, stating the filings were in compliance with the federal rules and that personal identifying information was redacted. However, confidential/private information was not redacted and became available to the public and viewable on the court's website. The lawyer admitted he failed to make reasonable efforts to supervise his non-lawyer employees, expressed remorse, and received a reprimand. Blogs. Just be careful. This lawyer had a public blog, and he was criticizing and saying really bad things about this judge. He was representing himself in a divorce case, saying she had an ugly, uncondescending attitude. She was an evil, unfair witch. He was prosecuted. He received a public reprimand in Florida. So, and that it's important to know. I have blogs. I just told you about mine, the Ethics Alert blog, but I don't put anything personal in it. This Illinois lawyer, public defender, assistant public defender, was blogging about things, and she was, turns out she was overworked and underpaid. And she was talking about a client who lied to a judge in a termination of probation hearing on a drug case, and lied and raised her right hand and said, "I'm not under the influence of any drugs and I haven't used any drugs." And she left the courtroom and told the lawyer, "Hey, I'm high right now. I've been taking drugs the entire time. Ha ha." And the lawyer, instead of reporting it or telling the client that he or she had to report it, put it in the blog. And the blog also said bad things about lawyers about judges using their initials. The lawyer was suspended for 60 days after she was reported. 60 days in Illinois. She was actually admitted initially in Wisconsin. She received a 90-day suspension in Wisconsin. In this Georgia Supreme Court case involving Ms. Skinner, this is a response to a negative review where the lawyer provided confidential information in response to a consumer internet page complaint, and that lawyer was prosecuted and received a public reprimand as well. And there's a New York State ethics opinion that says that lawyers cannot reveal client confidences solely to respond to a former client's criticism on a lawyer website. How about ethics in social media? This is not a social media webinar, but I did want to go over a few things. Hopefully we'll have enough time. I think we have 6 minutes, so I'll probably move forward on this. But just keep in mind that ethics opinions, cases, including this Robert Telly case in New Jersey, say that lawyers cannot try to friend or become friends with a opposing party or a witness without telling them who they are. Basically, if it's done that way and there's no or ask a paralegal to do it, because that's a violation of the rules. The New Jersey Supreme Court in this Robert Telly case ruled that attorneys could be prosecuted for disciplinary rule violations for improperly accessing an opposing party's Facebook page. And what happened in that case is the lawyers were found guilty, but the court, after waiting a number of years, said, we aren't going to discipline these. We're not going to sanction these lawyers, but this is a shot across the bow. Every lawyer needs to know that this is our rule, and don't try to, and that applies to any, don't try to surreptitiously access social media, including Facebook and other types of social media. we have a ton of them now, so I'm not going to try to run by, but we all know we have a lot of social media pages nowadays for social media. All right. This I'm going to pass on. It's basically, can the lawyer advise the client to change the privacy settings? This ethics opinion said, yes, they can. They just need to hold on to what was removed in case in the event that there's an issue with regard to preservation and or spoliation. The New York City Lawyers Association opinion agreed. So here's some more negative reviews just to nail it down so you have it in your materials. Here are lawyers who were one in DC receiving an admonition for revealing client confidences and responding to a client's negative website comments. Colorado's attorney was suspended for 6 months in 2016 after he responded to a negative online review and revealed, among other things, that the client had bounced a check and committed unrelated felonies. New York ethics opinion says that lawyers cannot reveal client confidences solely to respond to a former client's criticism. There's no exception, basically, under to the confidentiality rules. What the court said on that one. A Georgia lawyer was reprimanded for violating. This is the Skinner matter. It's got some details as to what the case said. I'll commend that to your reading later. All right. So here's another Illinois matter. Illinois lawyer stipulated to a public reprimand for, among other things, violating client confidences in a response to an unfavorable client review on AVO, however you want to pronounce it. So there's another example of social media where a lawyer can be criticized. Google reviews, AVO, all those things. Unless the states change their position and make it an exception, lawyers cannot put confidential information in responses to client negative reviews or client internet complaints, as the Georgia Supreme Court called it. So in this case, the attorney responded to a negative post and revealed confidential information about the case. All right. So moving along from that, client file management tips. Here's my recommendations, and depending on your practice, hopefully this will be helpful. Have checklists for managing case deadlines, especially when you have a practice where there are case deadlines. Have a pleadings index, communication records and logs, time entries, billing logs, discovery research. There are programs that there are third-party vendors who offer these. Time Matters, I think, is one. Offer an opportunity for this to be done, especially. I don't know if I don't want to point out the one particular thing, but communication records are really important. In my practice, if a lawyer receives a bar complaint, and there have been a lot of communications, including ones that are oral communications, if the lawyer has a way to capture those communications in logs that aren't, provided to the client, they're just internal logs. I've found it helpful that in my cases that I've handled for lawyers, if those are available, they're hugely important because they show, hey, the lawyer was doing this, the client was saying these things contemporaneous to when the issues or when the communications occurred. Always keep a calendar, have to-do lists, tickle system, that kind of a thing. Always, it's important to reasonably communicate with the client and promptly respond to telephone calls. The communication rule requires reasonable communication. The lawyer doesn't have to respond to telephone calls and emails. It could be the paralegal's job or a non-lawyer's job to respond within 24 to 48 hours and say, we received your email or your communication. How can we help, basically? And if it's a legal question, pass it off to the lawyer. Don't give legal advice and don't provide legal information, but also document the communications. It's hugely important to document communications. From my experience being decades long, not only 8 years of prosecution and decades long defense. Be careful what you say in emails. Don't assume it's going to stay confidential because many times it doesn't. And I've said this for decades as well. Cool off before, if you receive a completely unprofessional email from the opposing counsel or from the client, and you're really steamed up about it, don't respond right away, and also run it by somebody else, somebody who's objective, another lawyer in the firm. Because if something, and there's an example is I've defended a lawyer who actually was found not guilty, but who had received an unprofessional email on a case that was really, really difficult, had been going on for a number of years, said some things he shouldn't have said. The opposing law firm filed a motion for sanctions against him. It was sent to the Florida bar. I helped him out. He was found not guilty, but it was not fun, not easy, and it can be corrected by being careful what you say in your emails, and as if it's going to be reviewed by everybody, including the Florida bar. Also, always relay settlement offers in writing, and whenever possible, get your client's authority to settle in writing. I had an example of that. I think we're pretty much out of time, so I think what I'm going to do right now is I'm going to stop right now. Nina, I know we need to go over questions.
Wonderful. Thank you, Joseph. We'll take a few questions. But we have a couple of questions. So this first one is from an anonymous attendee. They ask, in rapidly evolving areas of law, I've noticed some firms have started offering subscription-based, whether it's monthly or annual, unlimited calls. What would you say is the best practice for non-engagement and assuring that the client doesn't think you represent them for everything if you are offering a subscription model?
Excellent question. And that's really interesting question. I'd like to address that by saying always disclaim or disclose if there's this subscription-based monthly or annual unlimited calls, there should be a disclaimer. We'll give you information. However, this does not create an attorney-client relationship. It is a little bit problematic, though, to have unlimited calls and then say we're not going to represent you, because they're going to have legal questions. So it's going to potentially create that attorney-client confidentiality issue. So it's really, and I'd like to know more about this, because I don't know enough about it to be able to answer more specifically. But disclosures and disclaimers are hugely important. I think that in that case, that should be strongly considered. And then maybe some other issues related to, hey, we're giving you basic information. We're not establishing an attorney-client relationship. Okay.
Absolutely. Thank you, Joseph, for that insight. Our next question is, for retainers, is there a best practice on the standard of competence related to professional rules, or no negligence as the standard of professional conduct? Some individuals bring contract suits instead of malpractice suits if there's an issue down the line.
That's actually a great question. So a contract claim, and as I tell everybody when I talk about fee agreements, which I didn't get to today, I'm sorry, but a fee agreement, I may have mentioned it briefly, fee agreements are contracts and they're legally binding. So lawyers need to be very wary of what is put into a contract, because violating the contract terms goes both ways. Client and lawyer are required to comply with the contract terms. So yes, it would potentially create a contract action. So the wording of the fee agreement needs to be very carefully, and I've helped lawyers with this, with issues related to fee agreements many times, and but also a contract lawyer, obviously, because these are contracts. So we should never forget as lawyers that our fee agreements are contracts, and so that they have to be abided by or complied with by both the client and the lawyer. Okay.
Thank you, Joseph. Our next question is, what would you say are some effective client intake red flags to make note of, where you can identify maybe some potential ethical problems before representation begins?
As I said, unreasonable expectations, argumentativeness. That's why I tell lawyers all the time, you should be involved in the intake, in the initial consultation, to read the client's personality, whether it's going to be a mesh with the law firm, whether they're going to have unreasonable expectations. As I said, whether they're argumentative and won't listen to the lawyer. All those things are really important. So as I said, it's important for the lawyer to get a flavor of that before the representation begins, including, even nowadays, even if it's a Zoom call, better it'd be, I believe it's better to be in person, but even if it's a Zoom call, a lot of that could be determined through that Zoom call.
Thank you. Our next question is, how do you handle a situation where you discover a conflict of interest mid-representation, especially if both clients want to continue with your firm?
Well, if it's a conflict that can't be waived, then the lawyer has to withdraw. If it can be waived, then the clients need to be both fully there has to be full disclosure with an informed consent. We want you to continue to assist us despite this. If it's not so adverse that the lawyer can obtain a valid conflict of interest waiver, then the lawyer could obtain that waiver and continue to represent multiple clients.
Absolutely. Thank you, Joseph. And then our last question for today is, when you're screening for conflicts, how detailed should our internal databases be to balance both thoroughness for the firm and client confidentiality?
So they need to be thorough enough to know what the clients' names are, who the opposing parties are, what the nature is of the representation, and that's basically it. Now, the law firm, if the law firm has a conflict of interest because of because it's discovered in the native database, I'll remind you. I didn't say this maybe I'll tell you. I would recommend the client whose the declination letter shouldn't say why the firm is declining the representation. Not even say that this being declined for a conflict of interest reason. It's just we're unable to take your case. We'll thanks for contacting us, but not an identification of why the case was declined or why the matter was declined, because that would that essentially saying there's a conflict of interest would pretty much be a violation of potential violation of confidentiality.
Awesome. Well, thank you so much, Joseph, for this wonderful presentation and answering all of our audience questions. We really appreciate it. And thank you to you all for submitting your questions. We always appreciate your participation. As Joseph mentioned, there is some additional materials that are in the slides. So as I mentioned at the top of the presentation, if you'd like to download those materials, you can always visit the webinar page, log into your account, and then there will be a button just below the thumbnail for you to access those if you'd like to review them. We want to thank you all so much for joining us for another Justia webinar. I wanted to remind you all, as I did at the top of the presentation, of the services available to you through our website platform, Justia Elevate. It's our innovative, feature-packed website solution designed specifically for law firms. It's built on a WordPress-based platform and offers you tools like the Justia AI Writer so you can create content for your website, access to the AI-powered Justia chat to boost your leads, and our new feature, FAQs for AI, to help better your chances of showing up in AI results. You'll have everything that you need to stand out online, and plans start at just $82.50 a month when paid annually. So if you'd like to learn more, you can visit that link in the chat, elevate.justia.com/price. Have a wonderful rest of your day, and thank you so much for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.